My father laughed in open court. Not the kind of laugh that stays quiet in your throat. The kind that fills a room and expects everyone to agree with it. He turned from the plaintiff's table to face me directly, loud enough for every single person in the gallery to hear exactly what he said. 4 words. No lawyer, you're finished. Then he added another sentence because he believed the first sentence should always be followed by something that made it feel generous by comparison. This is a courtroom, Isabel, not a military base. Your rank means nothing here. 22 people in that gallery heard it. The court reporter's fingers paused for half a second, then kept moving. Edward Grant, my father's attorney, had spent 11 years in estate litigation. His client list included 2 members of parliament and the chairman of a regional investment firm. He allowed himself a small, controlled smile. The kind of smile that says the outcome has already been decided and the rest of the morning is just procedure. I looked at my father, then I looked at Edward Grant. Then I looked at the sealed envelope sitting in the court clerk's file. The one my grandfather had prepared back in October. The one addressed in his own handwriting with instructions to open it only if someone challenged his estate. I didn't respond to my father's comment. Not because I had nothing to say. What I had to say was in that envelope. It was in the folder I had placed on the defense table when I sat down. It was in 13 years of a career that no one in that room, including Edward Grant, had thought to look up before this morning. They believed they were walking into the easiest case they would see all quarter. I had been preparing for this proceeding in one form or another for 3 years. What none of them knew, not my father, not Edward Grant, not the 22 people who had come to watch the Ashford estate hearing wrap itself up in one afternoon, was that I was a major in the Judge Advocate General's Corps of the British Army, that I had been a licensed solicitor for 13 years, that I had tried cases in military courts and advised commanders on matters of international law, that I had spent more hours inside legal proceedings than most people working in that building had spent in their entire careers combined, and that the sealed envelope in the clerk's file contained a letter my grandfather had written specifically for this morning. 2 pages in his own handwriting addressed directly to the court. He had known they would try to challenge it. He had prepared accordingly. So had I. There is a version of my childhood that looks uncomplicated from the outside. Manchester in the 1990s. A house with a garden and a swimming pool. A father who drove a good car. A mother who organized school fundraisers with the precision of someone who understood that visibility in a community required constant, sustained effort. Marcus was the older child, the easy one, the one who fit the shape of what my father had imagined a son would be. I was the younger one, the reader, the one who asked too many questions at dinner and had to be reminded occasionally that a question framed as a challenge is not the same as a question framed as genuine curiosity. I did not always make that distinction cleanly. My mother left when I was 14. It wasn't dramatic. It was the quiet dissolution of a marriage that had been running on obligation longer than either of them had actually admitted to themselves. When she left, she moved to Edinburgh and called on Sundays. She sent birthday cards that arrived without fail on the correct day. I do not have a complicated relationship with her departure. She was not the parent I had been trying to reach. After she left, it was the 3 of us. My father, Marcus, and me. The particular geometry of that triangle. 2 people who understood each other easily, and 1 person who required significantly more translation than anyone was prepared to provide became, over the subsequent years, the defining fact of my family life. I was not a difficult child. I was precise. I was argumentative in the specific sense of someone who has noticed an inconsistency and cannot let it pass without comment. I cared about accuracy in a way that, in a family built on the confident assertion of things that were mostly but not always true, made me occasionally inconvenient. My grandfather noticed. He had always noticed. From the time I was 8 years old and started politely but correctly correcting his crossword puzzle answers, he had watched me with the particular attention of a man who recognizes something in a child that the child's immediate environment has not yet found a practical use for. He was the one who suggested law school. Not my father. My father had suggested business. He had always suggested business. He had built his entire world on the premise that business was the organizing principle of a well-lived life, and that departures from it required thorough justification. My grandfather sat across from me at his kitchen table when I was 19 and asked me a simple question. What are you actually good at? I said, analysis. Finding the exact point where a position fails. He nodded. Law, he said. One word. I went to university at Oxford. I passed the bar exam in the summer I graduated. And then, to my father's sustained confusion and my grandfather's quiet, private approval, I commissioned as a JAG officer and reported to RAF Northolt in September of the year I turned 26. My father called it a detour. He used that specific word for 4 years. Your detour. Before he stopped mentioning it entirely, which I understood to mean he had reclassified it from temporary to permanent and adjusted his expectations accordingly. He did not ask me what I did. He did not ask about cases or deployments, or the specific texture of a career in military law. At family dinners when my work came up, he summarized it the way people summarize things they have not bothered to understand. She does legal work for the army. Something along those lines. Geoffrey Ashford, my grandfather, asked different questions. He had served in the Falkland Islands in 1982 and understood from direct experience what it meant to be part of an institution with its own culture and its own legal system. He asked me about the military justice code. He asked me about the difference between a general court-martial and a summary court-martial. He asked me once about a case I had worked on that involved rules of engagement in a deployed environment, and he listened for 40 minutes without interrupting. At the end he said, "You were right for the record." I told him the record had agreed with me. He smiled. He was not a man who smiled frequently. When he did, it meant something significant. The JAG Corps was not a well-known institution in my father's social circle. His friends understood law as a tool for protecting assets and closing transactions. The idea of law as a form of service, something you practiced in service of an institution rather than a client who paid by the hour, was not a framework they had any occasion to encounter. When I tried to explain what JAG officers actually did, my father listened with the expression he wore when he was being polite about something he did not find interesting. He would nod. He would ask about deployment with the vague discomfort of someone who prefers not to think about the specific places I had been. Then he would change the subject. My grandfather never changed the subject. He had the focused attention of a man who had spent 30 years running a business that required him to understand things quickly and completely, and who was now applying that capacity to the things he found genuinely interesting. He found me genuinely interesting. I had understood this since I was 8 years old. I had not, until the last years of his life, fully understood what it meant. That being seen clearly by someone is one of the rarest experiences a person can have. That the people who see you clearly tend to be the ones who trust you when it actually matters. His illness began in the spring of his 81st year. A diagnosis his doctor described with clinical precision, and Geoffrey described with the same economy he applied to everything. A problem that was manageable if approached correctly, and he intended to approach it correctly. He told my father and Marcus in a brief phone call that there was a health matter he was managing, and that he would let them know if it became relevant. He called me separately and told me everything. There were small moments across those years that I catalogued without meaning to. The way you catalogue things you tell yourself don't matter, and then find yourself returning to at 2 a.m. in a forward operating base on the other side of the world. The year I made honor roll for the 3rd consecutive term. Marcus received a bonus from my father's company, and there was a dinner to celebrate. I attended. My honor roll certificate was on the kitchen counter when I came home. No one had moved it. The year I qualified for a regional debate championship and won. My father was at a client dinner. He heard about it from my mother, who left me a voice message that began, "Your father says congratulations." He had not called directly. I understood what that meant, and I filed it in the same internal space where I filed other things I had decided not to spend energy thinking about. The year I told my father I wanted to go to law school. He said that was fine, but to think about what I was going to do with it afterward, because a law degree without a practice was an expensive piece of paper. I told him I had a plan. He said he hoped the plan was practical. I commissioned into the JAG Corps 8 months later. He did not come to the ceremony. He had a conflict he described as unavoidable and sent a card that said he was proud of me, signed with his name. No additional words. My grandfather came to the ceremony. He drove 4 hours from his home. He stood in the middle of a crowd of families and watched me receive my commission with the focused, unhurried attention he brought to everything worth watching. Afterward, he shook my hand. Not a hug, a handshake, firm and deliberate. That was correctly done, he said. It was, I understood, the highest compliment in his entire vocabulary. I thanked him. We had lunch. He drove 4 hours back home. He did not make a production out of any of it. That was my grandfather. That was the man who wrote 2 pages in his own handwriting and placed them in a sealed envelope in a court clerk's file because he had decided that when the time came, he wanted to be in the room. I flew home the following weekend. I sat in his study. The room with accumulated decades of books, the east window, the smell of a space that had been lived in rather than designed. He told me the diagnosis and the prognosis and what he thought about what the doctors had said, which was that they were probably right, but that he intended to be the exception to whatever they were projecting. He was, for 14 months, and then he wasn't. In those 14 months, I flew home 13 times. I used personal leave days and schedule windows, and once a compassionate leave provision my commanding officer approved, without requiring me to explain the full context. Each trip was Thursday night to Monday morning, sometimes Friday to Sunday if the duty schedule was tight. I did not tell my father about the trips, not out of secrecy, but because my father had not asked. And I had learned by that point that offering information to people who have demonstrated no interest in it is a form of performance I was not prepared to give. The first trip in April of his first year of illness, I flew on a Thursday night flight from a duty station in Hampshire. I landed at Manchester International at 6:14 in the morning. I took a cab to his house and found him at his kitchen table with coffee and the newspaper, exactly as he had always been. He looked thinner than I had expected. He did not make a production of that either. We spent 3 days talking, not about the illness. That topic was addressed once, briefly and factually, on the first morning, and then set aside as a matter that had been discussed and did not require further discussion. We talked about what he had been reading, about a legal case in the news that he had questions about what I was working on in the general terms that security clearances permitted. He listened. He asked follow-up questions. He was on a Saturday morning in April, with the Manchester light coming through his kitchen window. The same man he had always been, just slightly slower to stand up from the table. I flew back Monday morning. I told no one I had been there, not because it was secret, but because it was not, in my understanding of it, remarkable. It was simply what you did for someone who mattered to you in the time you had available. The subsequent trips followed the same pattern. I would identify a window in the duty schedule, a long weekend, a stretch of training days that allowed leave. Once a genuine emergency my commanding officer accommodated without requiring extensive justification, I would book the cheapest available flight. I would spend the time in Manchester. I would return and go back to work. My grandfather noted each visit in a small calendar he kept on his desk. I did not know this until after he died, when his attorney mentioned that Jeffrey had referred to the calendar during their meetings and had been precise about all the dates. 13 visits, names, dates, how long each one lasted, kept in his own handwriting in the same desk where he kept everything else that mattered. He was a man who documented the things he found important. The calendar was, in retrospect, a form of preparation. My father visited twice in the final year. The October visit produced 4 photographs for the family newsletter. Jeffrey in the garden, Jeffrey at the kitchen table, my father and Jeffrey together in the study. The newsletter ran them in a spread titled A Family Conversation About Legacy. I was not in any of the photographs. I had been there 2 weekends before. There had been no camera. The October visit was also the visit during which my grandfather asked me to stay an extra day. The study was quiet. Late afternoon, the light through the east window had gone from gold to grey. Jeffrey sat in the chair he had occupied for 30 years and looked at me with the directness that had always been his most consistent quality. "I've made my decisions about the estate," he said. "I want you to know what they are," he told me. I listened without interrupting. When he finished, I asked him once whether his attorney, his own attorney, not anyone connected to the family, had reviewed the documents. He said yes. Filed. Witnessed. Legally unambiguous. "They're going to challenge it," he said. "Probably," I said. "Will you be able to handle it?" I thought about 13 years of courtrooms, about the specific skill of walking into a room where the other side believes the outcome is already decided and demonstrating methodically that it is not. Yes, I said. He nodded once. Final. Good. He was quiet for a moment, and in that quiet I could hear the house. The particular silence of a space that has been inhabited by one person for a long time, and has taken on the quality of that person's solitude. The clock on the bookshelf. The settling of the old wood in the walls. Then he said something I have thought about many times since. You're the only one in this family who understands that what you do is more important than what people think you do. He said it the way he said things that mattered, once clearly, without inflection designed to underline the importance of what he was saying. The importance was in the words themselves. He trusted you to hear it. I did not respond immediately. There was nothing to respond to. It was not a statement that invited confirmation or denial. It was simply accurate in the way that observations made by people who have been watching carefully for 30 years tend to be accurate. He looked out the east window. The grey light was almost gone. That's why, he said. And then he asked if I wanted more coffee because he was Jeffrey Ashford, and he had said what he needed to say and saw no reason to add to it. We had coffee. We talked about other things, a book he had been reading, a news item he had questions about, a procedural matter in a case I had mentioned to him in the spring that he had followed with the attentiveness he brought to everything I told him. We talked until the light was gone and the room was lit only by the lamp on his desk. I flew home Monday morning. He died in December. The will was read in January, and in February my father retained Edward Grant and filed suit. The filing produced in the weeks that followed the particular kind of family noise that travels through relatives who feel they should be informed and end up passing along information degraded by each transmission. I received calls from 2 cousins I spoke to, perhaps once a year. Both asked questions that made clear they had been briefed by someone on my father's side. An aunt sent an email suggesting mediation addressed only to me, not to my father or Marcus, in which the comfortable resolution she was describing involved me accepting less than the will specified in exchange for ending the proceedings. I did not respond to the email. I forwarded it to my attorney. What struck me throughout this period was the consistency of the underlying assumption that I would fold, that I would find the cost of not folding higher than the cost of simply accepting whatever version of events my father was offering. The assumption was not unreasonable. It was based on 38 years of evidence. I had spent a long time being the person who could handle it, who absorbed what was required and continued functioning. They had not adjusted for 13 years of JAG training. They had not considered that the moment to establish your position is before the proceeding begins, and that the proceeding itself is the formal confirmation of preparation, done long in advance. Marcus sent one text message during the 6 weeks before the hearing. It said, "I hope you know this isn't personal." I read it twice, put my phone face down, went back to my preparation materials. It was, of course, entirely personal. That was precisely what made it worth preparing for. My preparation during those 6 weeks was methodical in the way that preparation for any serious proceeding is methodical. Not anxious, not obsessive, but organized. I reviewed the estate documents. I read Edward Grant's case history and identified the arguments he was most likely to deploy and the weaknesses in those arguments that the record would expose. I spoke to Margaret Stone, who had agreed to testify, and reviewed her documentation. I confirmed through channels available to me in my professional capacity the specific legal standards applicable to undue influence claims in English estate proceedings. I also reviewed more than once the documentation of my 13 visits, the flight records, the visitor logs, the dates and times and specific details that form the evidentiary record of what I had actually done during the 3 years of my grandfather's illness. I was not reviewing it for my own reassurance. I was reviewing it to understand exactly what it said in the precise terms that a judge would apply to it under the specific legal standards applicable to this proceeding. My grandfather had kept a calendar. His attorney had copies of the relevant entries. Margaret Stone's notes contained references to the visits. The flight records were documentation. The visitor logs from the care facility were documentation. The wire transfers for the tickets, booked always at the last minute, always on the cheapest available flight, were documentation. The record, in other words, existed. It had always existed. It had simply not been assembled in a form designed to be read aloud in a courtroom. I assembled it. I confirmed each element was admissible under British evidence standards. I organized it in the order I intended to present it. And then on the morning of the hearing, I drove to the courthouse, confirmed the sealed envelope was in the clerk's file, and sat down at the defense table to wait. The morning of the hearing, I arrived at the courthouse at 8:45. Grey. Manchester morning. The kind that gives the city its particular winter flatness. Just grey and present and indifferent to whatever is happening inside the buildings it surrounds. The courthouse lobby smelled of floor cleaner and the staleness of a building that processes 100 disputes a day and has long since stopped being affected by any of them. I confirmed the sealed envelope was in the clerk's file. Jeffrey's letter. Delivered to the court in October to be opened only in the event of a legal challenge. The clerk confirmed it was there. I went to my courtroom. I was the first one in. 12 rows of gallery seating, grey carpet, fluorescent lights humming just below the register of annoyance. I sat at the defense table, placed my folder in front of me, waited. 9 minutes before the judge entered, I sat with my hands flat on the table and looked at the clock on the wall above the judge's bench. 9 minutes is a long time in a quiet room, long enough to notice the grey carpet worn thin near the aisle. The scratch on the left side of the witness stand that someone had attempted to sand down without full success. The particular quality of fluorescent light that makes everyone look slightly more tired than they actually are. Harold Betts was in the 7th row. He had served with my grandfather in the Falkland Islands and was 85 years old and walked with a cane. He sat with his hands folded on top of it and watched the room fill with the patient attention of a man who has spent 85 years learning that the things worth watching reveal themselves if you give them enough time. He had been at my grandfather's funeral. He had shaken my hand and said without preface, "He talked about you more than you probably know." Then he had moved on to the next person in the receiving line because he was not a man who lingered. I had thought about that sentence many times. Sitting in that courtroom, watching the clock, I thought about it again, about the version of me my grandfather had carried and shared. Not the some kind of legal work version, not the detour version, but the version based on what he had actually observed. The sealed envelope in the clerk's file was that version written in his own words. Filed for exactly this morning. The clock reached 9:15. The judge entered. The room stood. The proceeding began. Edward Grant's opening was well prepared and professionally delivered. Undue influence. Inconsistency with documented prior intentions. A vulnerable elderly man and a legally trained relative with calculated access and clear motive. He framed it carefully, not as malice exactly, but as a concern about capacity and circumstance, which is the more legally useful framing and the harder one to directly refute. He spoke for 14 minutes. He described a pattern, my visits, my proximity to Jeffrey in his final years, my legal background that he presented as evidence of deliberate cultivation rather than genuine relationship. He acknowledged that I had visited frequently and described that frequency not as devotion but as strategy. He noted that Jeffrey Ashford had expressed in prior years intentions regarding his estate that differed from the will's provisions and suggested that those earlier expressions represented his authentic wishes before the influence had been applied. He was precise. He was organized. He was building toward a conclusion that had a certain internal logic. If you accepted the underlying premise that I had calculated over a period of years how to position myself to benefit from my grandfather's estate at the expense of my father and brother, the premise was false. But false premises presented with sufficient confidence and organizational precision can be persuasive. I had seen this in courtrooms. I had seen witnesses believe their own testimony sincerely and completely and have that testimony evaluated as credible by judges who had no reason to doubt it. Confidence is not the same as truth. Organization is not the same as accuracy. The record, however, does not care about confidence or organizational precision. The record simply is what it is. And what the record showed in this case was something considerably different from what Edward Grant was describing. He was good. I had expected him to be good. When the judge asked the respondent to make an opening statement, I stood. My father's laugh came immediately. Loud, certain, calibrated to fill the room. No lawyer. You're finished. This is a courtroom, Isabel, not a military base. Your rank means nothing here. Harold Betts in the 7th row looked at his hands. Edward Grant allowed himself a small smile. He settled back in his chair with the ease of someone who has just watched the opposition make an unforced error. I looked at my father, then at Edward Grant, then at the judge. I opened my folder. I placed my bar credentials and my JAG commission on the table, both face up, clearly legible. Then I looked at the judge. Your Honor, before I make my opening statement, I would like to enter my credentials for the record. Edward Grant's pen stopped. I am a member of the British Law Society, admission number 287441. I have held that membership for 13 years. I paused for one beat. I am also a major in the Judge Advocate General's Corps, British Army. I have been a JAG officer for 13 years. I have tried cases in military courts, advised commanders on matters of international law, and spent the better part of a decade in legal proceedings that required a level of preparation I have applied to this one. I looked up. Edward Grant was looking at my credentials, the way people look at a document that has just changed the nature of a situation they believed they understood. He read them. He looked at me. He read them again. His expression did not collapse. He was too professional for that, but something in the architecture of his certainty shifted, a small visible recalibration. The judge looked at the documents, then at me. Major Ashford, she said. You may proceed. The gallery went still. Not the polite quiet of people being careful with one another. The particular stillness of 22 people who have just understood that the story they came to watch is not the story that is actually happening. My father had stopped smiling. He was looking at me with an expression I had not seen in 38 years of being his daughter. Not irritation, not neutrality, something more fundamental. The expression of a man standing in a room he believed he controlled, discovering that the room has a different architecture than he thought. I proceeded. I addressed each element of Edward Grant's undue influence claim. I presented documentation of my 13 visits, dates, flight records, hospital visitor logs, the specific timestamps of entry and exit from the care facility in the final 4 months. I presented without editorial comment the 2 occasions my father had visited in that same period, and the dates of the family newsletter issues in which photographs from those visits had appeared. Edward Grant objected twice. The judge overruled him both times. The second time she did it before he finished the sentence. Then I presented the testimony of Jeffrey's independent attorney, Margaret Stone, who had drafted the will and who confirmed under oath that she had met with Jeffrey Ashford on 4 separate occasions. Conducted capacity assessments consistent with best practices for elderly clients, and found him on every occasion to be entirely competent, entirely clear about his intentions, and entirely aware of the implications of what he was signing. Edward Grant cross-examined her for 11 minutes. He did not succeed in moving her on any significant point. He tried 3 angles. The first was to suggest that the capacity assessments she had conducted were insufficient in scope, that the standard she had applied was designed for clients with straightforward circumstances, and was inadequate for evaluating a client under the particular pressures of a contested family estate. She explained, calmly and with the patience of someone who has answered this question before, that the assessments she conducted exceeded the standard recommended by the Law Society for elderly clients in complex estate situations. The judge said that would not be necessary to elaborate further. The second angle was to suggest that my grandfather had expressed uncertainty about certain provisions of the will during their meetings. Margaret Stone said that was not her recollection. Edward Grant asked if she was certain. She said she was. He asked if she had notes from the meetings. She said they had been submitted to the court as part of her documentation. He looked at his own files for a moment. Then he moved to his third angle. The third angle was to suggest that the frequency of my visits was itself evidence of something that warranted investigation. Margaret Stone said that in her experience, a grandchild who visited 13 times over 3 years of illness was not unusual. She said it was in fact less common than it should be. Edward Grant started to ask a follow-up question. The judge told him she had heard enough on that point. He sat down. I had watched the entire cross-examination with my hands flat on the defense table. Across the room, my father watched it too. He had not, I thought, anticipated that Edward Grant would fail to move her. He had hired a good attorney and had arrived at the hearing expecting the good attorney to do what good attorneys did. Good attorneys are, however, limited by the quality of the underlying facts. The underlying facts in this case did not support the position Edward Grant had been hired to argue. He had not known that when he took the case. He knew it now. The room after Margaret Stone stepped down had a different atmosphere than when the morning began. Edward Grant's confidence was still visible. He was too professional for it not to be. But it had taken on the quality of something maintained through effort rather than something that simply existed. My father had stopped the small nods he had been giving during Edward Grant's opening. He was watching the proceeding with the careful attention of a man who has just begun to revise his understanding of where it is going. Marcus, in his seat beside my father, was looking at his phone under the table. He had been doing this intermittently since the credentials moment. The fact that he felt the need to look something up told me everything I needed to know about where the morning stood. Then I asked the clerk to open the sealed envelope. The room changed when the seal broke. Not dramatically, but the quality of the attention shifted. The way a room shifts when it understands that the thing it has been building toward is about to arrive. The judge read the letter silently first, both pages, taking her time. Then she read it aloud. Jeffrey Ashford had written clearly, and at length, he had written about the visits. All 13, logged by name and date. He had written that Isabel had come when he called, and had not brought a camera, and had not mentioned the visits to other family members. He had written about the October night she had sat with him until 3:00 in the morning when he could not sleep, and had gone back to her duty station on Monday, and had not, as far as he could determine, told anyone it had happened. He had written, "I know what undue influence looks like. I spent 30 years in business. I know the difference between someone who wants something from you and someone who simply shows up. My granddaughter showed up 13 times. She did not ask for anything. She did not suggest anything about the estate. On one occasion, I raised the subject myself, and she asked whether I had consulted an independent attorney. That is not the behavior of someone who is manipulating a vulnerable old man. That is the behavior of someone with professional ethics and a functional conscience." He had written near the end, "I have spent 81 years making decisions. I am making one now. The people contesting this decision are welcome to their opinion of my judgment. They have rarely sought it when I was alive. I see no particular reason to defer to them about it now that I'm not." The judge finished reading. She set the document down. The gallery was completely silent. Daniel had uncrossed his legs and crossed them again in the opposite direction. Marcus was looking at the table in front of him. Harold Betts had straightened in his seat. My father was looking at the letter, just the letter. At 2 pages of his father's handwriting that had just described in the specific and unsparing language of a man who did not traffic in vagueness, exactly who Jeffrey Ashford had trusted and exactly why. Edward Grant looked at his legal pad. He picked up his pen, set it down. "Your Honor," he said. His voice was professionally steady. Something underneath it was not. "I would like to request a brief recess." It was the first thing he had asked for all morning. The judge looked at him. Then she looked at me. "We will continue," she said. For the first time in my life, my father had nothing to say in a room he thought he controlled. Not anger in me. Not a triumph. Something quieter and more durable. The particular settled quality of a proceeding that has reached its correct conclusion and is in the process of confirming it. I delivered my closing statement in 12 minutes. I thanked the court and sat down. The judge ruled from the bench at 4:17 that afternoon. The challenge to the estate was dismissed and the will stood. Edward Grant's firm submitted their fee invoice the following Friday. The court had ordered costs to the respondent. My father paid it in the corridor outside after the ruling. My father found me. No Edward Grant, no Marcus. Just the two of us in a hallway that smelled of old carpet and courthouse coffee. He looked smaller than he had at the plaintiff's table. The same man, same posture, same grey at his temples. But something in the arrangement of his certainty had shifted. He was working to reassemble it and not quite managing. "I didn't know," he said. "The army, the bar. I didn't." "You never asked," I said. "Not once in 13 years. You never asked what I actually did." He was quiet. "You told me my rank meant nothing in that courtroom," I said. "The judge called me Major 14 times before noon." He had no answer for that. He looked at the end of the hallway, at the window, at the grey February light sitting flat on the parking structure below. "I'm not asking you to apologize," I said. "I'm asking you to stop telling people I manipulated Grandpa because you know that's not what happened. And I think somewhere you have always known who he trusted and why." He did not respond. I did not wait for him to. I went back inside and finished the day. What struck me standing in that corridor was not the conversation itself, but what was not in it. There was no moment in which he said he had been wrong about my career. No moment in which he acknowledged that some kind of legal work had turned out to be something specific and substantial that he could have known about if he had asked. No moment in which he connected the years of silence on that subject to the morning in the courtroom that had just concluded. He was not a man who made those connections out loud. He was, I had always understood, a man who processed things internally and arrived at conclusions privately and continued operating from those conclusions without extensive commentary. That was fine. It was how he had always been. I did not require him to be different. What I required was what I had asked for, that he stop telling people I had manipulated an old man, that the record of what had actually happened be allowed to exist without being overwritten by a story that served his understanding of events at the expense of the truth. Whether he would do that, I did not know. People do not always do what they say they will do. My father was not a man I had extensive recent evidence about, but I had said it clearly in the specific terms that left no room for misunderstanding, and I had meant all of it. The rest was his to decide. I went back inside. I finished the day. I drove to my hotel. I ate dinner. I reviewed a brief. I slept 8 hours. I went back to work. The record was filed. The ruling was on the court's calendar. And my grandfather's letter was, as of that afternoon, part of the permanent documentation of the proceeding. His words and his handwriting in the custody of the court, where they would remain. 6 weeks later, I established a scholarship in my grandfather's name through a legal aid organization he had supported for 20 years. The fund provides assistance to law students from lower income backgrounds who demonstrate academic merit and commitment to public service. I did not inform my father. He found out through the organization's annual report. He did not contact me about it. Rachel sent an email 2 months after the ruling. She said she was sorry for how things had gone. She said she had believed going into the hearing that the challenge had merit and that she had revised that view after the proceedings, and particularly after hearing the letter read aloud. She said our grandfather had been clear and that she should have understood that better before the lawsuit was filed. I read the email twice. Then I wrote back 1 paragraph, 3 sentences, and told her I appreciated her saying so, that I hoped she was well, and that I considered the matter closed. I meant all 3 of those things. The matter was closed, the record was filed, the ruling was final. Some things end not with reconciliation, but with accuracy. The accurate version of what happened is now part of the permanent court record of Manchester. That is not a small thing. It is in fact exactly the right thing. It is what my grandfather prepared for, what he filed for, what he trusted the court to keep safe. That is, when I think about it, the most useful summary of what he left me. Not the investment portfolio or the property holdings. Those are real, and they matter, and I am not pretending otherwise. But the more durable thing was the demonstration that the people who pay careful attention and document what they observe and trust, the people they have earned the right to trust, tend to reach correct conclusions. He had been watching for 30 years. He reached a conclusion. He filed it correctly with the appropriate authority, and when the right morning arrived, the record spoke. I have spent 13 years in a profession organized around the principle that the record is the most reliable witness in any proceeding, that what is documented, filed, and preserved under appropriate custody is more durable than what is remembered, asserted, or claimed, that the careful accumulation of evidence kept in the right place by the right people has a weight that argument and confidence cannot match. My grandfather was not a lawyer. He had never been to law school. But he understood this principle in the way that practical, honest people sometimes understand things that take other people years of formal training to internalize from watching what actually works over time. He watched for 30 years. He reached the right conclusion. He put it in the right place. I think about my grandfather often. Not about the estate. The estate matters, but it is not the thing I return to. I think about the study. The afternoon light through the east window going from gold to grey. The coffee. The particular economy of a man who, when he had something important to say, said it once clearly and trusted you to have been listening. He spent 81 years making decisions. He made the last one carefully with full understanding of what it would require, and he left a letter to make sure the record was complete. My father told me my rank meant nothing in that courtroom. He was thinking about the wrong document. The right document was 2 pages in my grandfather's handwriting, sitting in a sealed envelope in the clerk's file, waiting for exactly this morning. Some battles end not with an argument won, but with a correction made. Not loud, not triumphant, simply accurate. Placed in the right room, read aloud at the right time, and then filed correctly in the permanent record. My grandfather knew exactly who to trust. He put it in writing. The court kept it safe. I have been asked since the ruling whether I was angry at my father. The question assumes that anger was the appropriate response to what happened. That a daughter who was taken to court by her father and had to defend the terms of her grandfather's will against accusations of manipulation should feel above all else something hot and reactive and consuming. I did not feel that. I felt something more useful. The particular settled clarity of a proceeding that has been correctly resolved. The understanding that the record now reflects what actually happened, and that the record is permanent, and that the story my father had been telling about my relationship with my grandfather has been answered in a court of law with documentation. That is enough. It has always been enough. If you have ever walked into a room where someone had already decided you did not belong, where someone with confidence and volume told you that you were outmatched, that you should have known better than to show up, I want you to think about what was in your folder, what you had prepared, what they had not thought to look up before that morning. The people who underestimate you are not always wrong about everything, but they are wrong about that. They are always wrong about that. This is Hidden Family Infidelity and Revenge. Leave a comment and tell me where you are watching from. Tell me if you have ever walked into a room where someone had already written you off and what happened when they found out they were wrong. Tell me what was in your folder. If this story meant something to you, there are more.